No, that's consent in terms of this one party, Maria Battaglia, the security staff. This guy, right, happens to be using the very same tools, but he's not the guy I consented to. And this isn't the circumstances I consented to. Actually, as I say it out loud, it's not a bad argument at all.
No, it's a,
yeah.
it's
I think it might be a winner. It's probably a winner, yeah.
I mean, the policy would say, you know, you recognize and consent to MyTwitFace's monitoring of MyTwitFace computers. So I don't think that would be a very good argument to say that by agreeing to that, you've allowed this non-MyTwitFace person to come in and do the same thing. That could come up if the government did it, because and the analysis turns into a constitutional question, a Fourth Amendment question of whether you had a reasonable expectation of privacy that you gave away when you signed that agreement. Because the government's position is essentially that expectation of privacy is an on-off switch, and if you have given up an expectation of privacy as to one party, then you don't have an expectation of privacy in that information at all.
And that was the case. The Supreme Court just decided not to address that issue, and this was I'm sure some of you followed the SWAT team member who was given the text pager and then used it to trade messages with his wife and with his the woman he's having an affair with. And this was also the oral argument where Chief Justice Roberts said, now how does a pager work? What happens if someone's using their phone when you need to send them a page? And Justice Kennedy helpfully chimed in and said, I think you get a busy signal at that point. So it made you wonder about whether the Supreme Court was ready to decide this, but Kevin's right. Under the Fourth Amendment, it's absolutely give an inch, take a mile. You can't consent to lots and lots of, if you give your trash to your trash man, then you're also giving it to the rest of the world. I mean, that's just the way the Fourth Amendment works. Very, very different analysis than the one we did here.
I think we got about 10 minutes with other questions.
Weasel actually had a question.
Oh, sorry, okay.
Yeah, I had one real quick question. During the prosecution's closing arguments, the statement was made that the jury would have to go away to interpret the law. I was under the impression that it was the judge's job to interpret the law and the jury was supposed to interpret the facts.
Oh yeah, no, that's complete. You have it backwards. No, you're right. You're exactly right. One thing we manufactured in this case is this interstate question was really a very legal question, and legal questions usually don't go all the way to the jury. Right. And so we were faking that because we wanted you guys to think about interstate. But the jury probably would never be left with that ultimate question. They might be left with some of the surrounding questions. Where did the interception take place? Where on this, in respect to the network interface was it? But they definitely wouldn't get the ultimate legal question. So that was a very perceptive catch.
Go ahead.
Does the communication in question actually have to cross state lines, or does it just have to go over a system that crosses?
So only the system.
The latter.
Yeah. And the cases are actually specific on that. It says it does not have to have left the state.
Yeah.
Mm-hmm.
And just because the law professor in me wants to make this all about everything that you're reading about in the newspapers, you know, the reason we have interstate commerce requirements like that is because courts have said that's the only thing Congress can do. That's what distinguishes the feds from state legislatures. So Congress always has to make sure that there's an interstate component, but they can stretch it really far. And this has been ripped from the headlines because in all of the healthcare lawsuits where the state attorney generals are arguing that Obama's healthcare plan is unconstitutional, this is their argument. You're talking about something that's all within one state, and you're forcing people to do something, and this isn't the role of Congress. They're going to lose really badly, but this is very similar to the argument they're making. So.
Okay. Yeah.
I was wondering, why does it matter that, why would you not argue that because the screenshot was later sent across the internet, that it was not, how is that distinct from?
I think the argument there would be that there was no interception. So to intercept, and I was sort of trying to get at this in my motion. Under federal law, if you're a party to the communication, you can't intercept it because consent of a party makes it okay. And so the communication of the exploit sending the screen grab to him, he was a party to that communication, and that communication is a separate communication from the communications that Zuckerson was having with his friend in Alaska via IM.
So, is there a reason that you couldn't hook up, for a phone conversation, for example, hook something up to record that in place and then transmit it afterwards, and that's not an interception?
if you're a party to the phone call in the first place,
You can record it.
you can record it under federal
federal law.
but not under most.
Yeah, but his point is, if he was a party for the, this is why I asked you this question. Does your argument turn on him being a party? And you correctly answered no. Because if you'd said yes, I would have done what he did, and says, well, then why does the oral have to do with any of this?
I mean, I should have been clearer, because the point that I was sort of getting at there was that, yes, there was an electronic communication here that went to him, which was, the video screen capture being sent to him, but that's okay because he was a party. But the other communication that they're claiming was intercepted, which was the communications at the party that were captured, well, it was just silent video, and the statute doesn't cover that. And so that's what I was trying to get at.
Here.
I guess I had a question about the definition of the system. I think you brought one case that said, define the system very narrowly, and then I don't know how in this proceeding, when you said it wouldn't go to the jury, it would have been decided by the judge, but how can we expand the system to be all-encompassing when it's already narrowly defined?
So you're absolutely right. That would be a judge question. And one of the things that actually Paul was pointing out was that was a particular court, the Central District of California, and that means it's not binding on other courts. Even judges in the Central District they might tend not to, but they could disagree with it. So for California, the next level up is the Ninth Circuit, which is also for Nevada and Arizona and Hawaii and Alaska and several other western states. And so Ninth Circuit decisions are binding on district courts. Ninth Circuit is binding on all the district courts within its jurisdiction. And there are other circuits depending on where you are. And then the Supreme Court is binding on all of them.
Would it be a fool's errand to argue, for example, if one captured a VoIP call, that there's no auditory component because it doesn't become auditory until the data is processed through a codec that understands the data should be processed in consent?
We've heard this argument with encryption before. So the question was, is this too clever to say VoIP calls are not voice calls because they have to be post-processed in some way before they become voice? That seems like I think most judges, even not knowing a lot about computers, are going to be really suspicious about an argument like that, right?
I think the judges would do a force for those.
Yeah, with SS7 and with current digital telephony, I mean, that you would if I were the one arguing against it, I'd say, Your Honor, they're just trying to use some accident of technology to rewrite the entire statute, right? But with crypto, it's harder. I've heard people make the argument that, and there's one definition we didn't fight over here. In order to be a criminal under the statute, you have to obtain the substance, meaning, let me finish, or purport of a communication. And I've heard some people argue that with crypto, I don't know, maybe I don't have the substance, meaning, or purport yet, right? I mean, maybe. I thought it was Kevin. Someone with a feed that sounds just like Kevin. That's a pretty good. So anyway, so that's the, but I think most of us up here probably think that's kind of a crazy argument.
I don't think it's crazy.
Oh, you don't?
I mean, it is a colorable argument, as lawyers like to say, and if I were a defense attorney, I would certainly make it. I don't think there's any clear law on it. I think I don't think it's the best argument ever, but it is. I mean, I'll just say, in another context, when I was thinking about this and was thinking about VoIP as a wire communication, I did stop myself and go, wait a second. There really isn't any case law on this, and one could, so I've had the same thought, which makes it colorable.
Yeah, I mean, it
has 2 gigs.
So it's a sign of how complicated this statute, which is called the Wiretap Act or Title III, is, that in your answer, I think I spotted 7 legal issues and probably 14 cases. So understand, we presented one of those 7 in this trial, right? There's this whole thing called councilman, and Rick and I were the lawyers who litigated. I mean, we could talk about this all day long. It is an old statute that is really showing its age with the internet. And with every advance in communication technology, it just gets worse. And so lots of people may walk, and the government, let's not forget, this also concerns the government, like I said in my argument, the government may start to get really clever about how it gets around the statute. Well, maybe, possibly.
I'll just add a point to not self-promote, but promote the greater good. EFF is involved in an effort in Congress to, with many partners from both the civil liberties community and companies such as Google. We've been working with Richard to update this area of the law for the 21st century because it is so woefully outdated. And actually, I don't think that anything we're proposing would actually clarify the law on the points raised here, but which only just is a signal of how much work there is to be done here. But just so it's called digital due process. If you want to go check out what we're doing. In the back.
Yeah, just curious about, guys, for our, I'd like your opinion.
Raffle starting at 6.
Exactly.
By, get a raffle.
I mean, understand one thing, which is we had him dead to rights on a misdemeanor, so he was probably going to go to jail for something. Some misdemeanor people don't go to jail at all, but probably maybe for a few months. So this fight really was, it was a realistic fight. This happens with the Justice Department all the time. The FBI doesn't want to invest a lot of resources just for a misdemeanor. And so, this was all about the felony. As Kevin said when he led off, the whole keylogger, screen capture, ROP thing, that just can't be right. And so I hope we'd be able to convince a judge, not a jury, but a judge, to disagree with that other court and give us the verdict there. And the other one,
Apple iPad at 6:45.
Nice, 6:49. What was the other?
Someone's, okay.
Yeah.
The commercial advantage.
Oh, and the commercial and private advantage. We haven't talked about that at all. It's pretty broadly defined. I think the government would have won that one too.
I mean, it's defined as anything of value. I mean, I don't think I agree that the government would have necessarily won that, but nevertheless, the case law is defining it fairly broadly, and so in trying to make this an interesting case, we put a lot of effort into creating the hypothetical where he, our esteemed defendant is not getting any salary, not getting any money, he doesn't have a financial interest, and so on and so forth, which, there are people out there who do that, but it would have to be sort of a rare circumstance. One fact that might have complicated it further, which we discussed but ultimately didn't put in, was if the open source project was receiving donations as a result of this. That would be perhaps weigh a little bit more towards commercial advantage. So we tried to make it an interesting question, but I think in a typical scenario which was not so sort of carefully crafted to be interesting, it would be more likely that a commercial advantage would be found.
Cool, you want to call?
I think we're done.
Okay with that? 6 o'clock. Want to thank everybody for coming.
Appreciate it.
Thank
very
you.
much.